You start with some, are you allowed to? Okay. No more questions after those two guys.
Your grandfather in.
Yeah. Okay, go ahead, sir.
I'm running a 6,000 square foot grow, and I have 3 different dispensaries interested in working with me. Now, can they all be under the same optional premise license and be under the same address? If we separate grows in the actual warehouse?
Again, they need to be separate and distinct, and they need to be the ones that own the grow, not you. Okay. And whether it takes a chain link fence to the ceiling, barbed wire, I mean, whatever you want. I can't.
Can you repeat that, sir?
I said as long as it's divided in 3 different sections, it's appropriate.
Well, again, that's just one requirement for separate and distinct. They still need to be licensed and owned and everything correctly.
Okay, thank you very much.
Okay, go ahead, Dennis.
I was wondering, in regards to the 2-year residency and December 16th date, if you have decided who or what can qualify as a resident?
We have not at this point, and I have, as I mentioned, sought some guidance from my Attorney General.
My question kind of harps off the last gentleman's question. He mentioned the 3 the 3 separate dispensaries for his grow facility. Can he work for all 3 dispensaries at the same time?
He can as an employee, absolutely.
As an employee of each one of those, but still hold a lease for his facility that they're using, and they've got the license for, right?
You can, and there can be a bona fide landlord-tenant relationship, but and I want to be careful, and I want everybody to understand really where I'm going with this. I said bona fide landlord-tenant relationship. That means that if your neighbor's charging X number of dollars for rent, there should be a lease that's very commensurate to what rent goes for in that area, and that authorization or that enablement is not used as a subterfuge for hidden ownership for somebody that's otherwise prohibited from holding a license.
What he just said was no cheating.
Exactly. We agree again.
Mr. Cook, 2 quick questions. First question is, will you confirm that the medical marijuana licensing bond is not going to be required until next year, July of 2011?
I will.
Okay. And then my second question is, there's a lot of people in this industry, such as myself, that support the industry. Will we be required to have a separate license to be at these grow facilities or these dispensaries legitimately? So should I have a separate license as an insurance agent?
We're going to work through this again with rulemaking. Well, I mean, I keep coming back to it, but here's the reality. The law says you can't be in a limited access area or a grow area unless you're licensed. That's what the law says. Now, is it reasonable to expect your landlord? Is it reasonable to expect the electrician in the middle of the night when the power goes out? The refrigeration guy, all those kind of people to have a license, okay? Perhaps not. What may be a more reasonable test, which I'm going to have to promulgate a rule to make it happen, is that perhaps a key or an owner of that establishment has the ability to log people in and out, take them in, you know, let us know when they come in and out, all those kind of things. And those are really the regulatory tenets that make that kind of process work. But until we go down that road, I mean, I hate to keep going back there, but that is the reality.
Thanks, Mr. Cook.
Certainly.
My question is for Matt Cook. It's a 2-part question. Basically, there's a rumor going around as an edible infused manufacturer that you have to be tied to a dispensary. And so basically, my second question is, if that's not true, how are you going to base our plant count if we have an unlimited number of plants to grow?
I think you just answered your own question. You do not have to be tied. An edibles manufacturing license does not have to be tied to a dispensary. In fact, you're authorized to get up to 5 strains from different dispensaries to use in one of your edibles that you're making. You can have contracts with multiple dispensaries to acquire the meds that you need to make the edibles. And what was the second half of that? In terms of the plant count, I don't see a plant count restriction in the bill for an edibles manufacturing license.
We need to get a optional cultivation license if we want to grow in our own medical marijuana center.
The bill does require that, yes.
My question, can you hear me? Yes. My question is, as a caregiver,
prior to House Bill 1284 being signed by Governor Ritter, is I as a caregiver could grow 6 plants. My patient could also grow, but between the two of us, that number could only total 6. My question is, now with this, has that changed at all? Can he grow 6 and can I grow 6?
The patient's rights and the caregiver rights are protected by the Constitution, and I have no intent of intervening on those rights.
Thank you.
Yes, I have 2 different questions. Can one growth center cover for multiple dispensaries? Like, let's say I own 2 or 3 dispensaries. They're all in, let's say, my name. I own a facility that grows. Can I go over both dispensaries in my one center, or do I have to have 2 separate centers, or is it like you said, I have to split them up directly per dispensary?
Yes, they will have to be separate and distinct. Okay.
And then I have one more question. For what reason, residents from other states, can they not have a medical marijuana business in the state of Colorado?
That was a public policy decision in the General Assembly set forth in the legislation. I mean, I don't know
So
what the
basically,
intent
I
was
can't
behind
come
it.
from a different state and open a business in Colorado even if I pay taxes on it?
I'm sorry?
Like, let's say I come from a different state and I come here, let's say 6 months, 4 months, however months ago, and I decide I want to open a business here. I can't open any legitimate business here just because I'm not from the state.
No, you can't engage in this regulated occupation because the bill provides it. There's other examples out there of things that you can't do until you have certain residency requirements. The one off the top of my head, and I know this because I'm a sportsman, is a hunting and fishing license.
Okay, so I can't go get a fishing license if well, let's say I have a residence here, like I live here, I have a house here, but I've only had a house here for a month, I can't go get a fishing license, and I can't open a business here?
You can get a non-resident, but you can open a business. And I'm just using that as an example. The real answer is the law specifically prohibits the non-resident must meet the residency requirement.
What is that requirement?
Go ahead. I'm looking for clarification on the rumor for primary caregivers. I'm hearing that we can't sell our leftover product to anyone other than our particular patient. Could you help me with that?
Again, I have really nothing to do with the caregivers at all.
I got a couple thoughts on that. I mean, unfortunately, if you are currently, the way the law is constituted, if you are proceeding under the caregiver route, you probably shouldn't be selling to a licensed center, but really the risk is on the center, and the center probably won't be accepting caregiver medicine, at least in the short term, unfortunately.
The law states that you cannot consume or eat medical marijuana in a public place. What if we were to have a private club where people can come and store their stuff in lockers, they can come and partake in events and things happening at this place, where they can come and consume and enjoy their medicine in a place where it's private, it's not public?
Again, that's another topic for a little, and I hate going back there, but there's actually a precedent in law already in the alcohol beverage side of things. It's unlawful to consume in public places, and there are different, according to the law, there's case law to support this, different degrees of what public means. And I'm not trying to be technical, and I'm certainly not trying to sound like a lawyer, but I know that's probably out of town crush, but that will be something that'll have to be fleshed out.
Also, too, if you look at 1284, there appears to me at least to be a provision against cafes and that kind of thing. So to the extent that you're inviting people onto the premises to do that,
Well, the bill is private, that would be private. You have to pay to be part of this. It's not going to be public, it'd be private. It's like a private club. Literally, private.
I think you're going to wind up in rulemaking with that one, too.
I said lightly,
Also, for those people who decided to get into this business and grow in a residence up until recently, that was okay. For those people who still want to be compliant with 1284, how long do they have to leave their residence and find a warehouse space to continue doing what they're doing?
I guess that's for me again, but again, HB 1284 does not go into effect until July 1 of next